Hey there, folks. Imagine this. In a stunning legal victory, the Trump administration has just been cleared to send National Guard troops straight into Portland, Oregon, overturning a block that was keeping them out. This decision isn't just about troops. It's a heated clash over power, protests, and who gets to control law and order in the streets. But here's where it gets controversial. Does this protect federal buildings, or does it stomp on local rights? Stick around as we unpack the details and explore why this ruling has everyone talking. Diving deeper, on October 20th, 2025, a three-judge panel from the Ninth Circuit Court of Appeals made waves by lifting a temporary restraining order, or TRO for short. For beginners, think of a TRO like a quick courtroom pause button that stops something from happening while judges sort out the legal arguments. In this case, it had been halting the deployment of Oregon's own National Guard troops to Portland. Now, with the TRO gone, the Trump administration can move forward with sending those uniformed personnel into the city to safeguard federal property. But wait, this isn't a free pass for just anyone. There's still a bigger, broader order in place that bans National Guard units from any other state from stepping into Portland. So, we're talking about Oregon troops for Oregon soil, but only if federal approval comes through. It's a nuanced distinction that highlights the tension between state autonomy and federal authority. And this is the part most people miss: the fine line between local control and national intervention. Oregon's Attorney General, Dan Rayfield, wasn't shy about his frustration. He slammed the ruling, accusing the appeals court judges of letting the president dodge accountability. In his words, the panel has chosen to not hold the president accountable. Rayfield warned that the Trump team might now push to dismantle that larger TRO, blocking out-of-state guards. And he urged the full Ninth Circuit to reverse Monday's decision before any illegal deployments could roll out. We'll continue to fight for Oregon's laws and values, no matter what, he vowed, painting a picture of ongoing resistance. To set the scene, let's rewind to late September when President Donald Trump issued an executive order to federalize, meaning take control of, around 200 members of the Oregon National Guard. The goal? To protect a federal immigration and customs enforcement, ICE, facility in Portland, amid what the administration called disruptive protests. For context, these demonstrations have been fueled by concerns over immigration policies, with some turning confrontational. And local leaders had already voiced their objections to federal troops intervening in what they saw as a city matter. Portland and the state of Oregon didn't take this lying down. They sued. Enter U.S. District Judge Karen Immergut, who earlier this month issued that TRO based on her assessment that the situation in Portland wasn't violent enough to warrant a federal takeover. She described the president's claims as simply untethered to the facts, pointing out that while some protests were peaceful, the overall environment didn't justify stripping the state of its militia control. Militia, by the way, is another word for the National Guard, which typically falls under state command unless federalized, like in emergencies. But the appeals court flipped the script on Monday. Their ruling suggested the Trump administration had a strong chance of winning the full appeal, stating that it is likely that the president lawfully exercised his statutory authority to federalize the Guard. This authority comes from laws allowing the president to call up state troops for federal duties, especially to protect government property. Interestingly, the majority opinion came from two judges nominated by Trump himself, Ryan Nelson and Bridget Bade, who acknowledged that while some ICE protests were peaceful, many had escalated to violence, with threats aimed at federal officers and the building itself. On the other side, Judge Susan Graber, appointed by former President Bill Clinton, dissented sharply. She called the decision not merely absurd and argued it undermines key constitutional protections, like states' rights to manage their own militias and citizens' First Amendment freedoms to assemble and criticize government actions. For example, imagine if every protest near a federal site led to military deployment. That could chill free speech nationwide. It's a compelling counterpoint that raises eyebrows about balancing security with civil liberties. And just to add another layer, Judge Immergut had slapped on a second TRO after the administration tried to bring in California National Guard troops, which the Trump side hasn't challenged yet. So, the battle lines are still drawn, with more legal skirmishes potentially ahead. This unfolding drama touches on big questions about democracy in action. Is deploying troops the right way to handle protests, or does it risk turning peaceful dissent into something more volatile? And here's the controversial twist. Some might argue it's a necessary shield for federal workers and buildings, while others see it as an overreach that favors executive power over states' independence. What do you think? Does this ruling uphold the law or undermine it? Should presidents have such broad authority to federalize local forces? Or is this a slippery slope toward over-militarization of protests? Share your opinions in the comments below. I'd love to hear your take and spark a discussion.